The government has released the first set of draft rules for the companies. The list of mandatory requirements from the auditor has grown longer and includes disclosure on companies' litigation and derivative exposures. But that apart, it's the retrospective implementation of the auditor's rotation clause that has got the companies worried. Rukmani Rao takes us through the contours of the new draft rules. While the draft new rules chart out clear details on rotation of auditors, it has also indicated the period of computation for rotation of auditors will come into effect retrospectively. The draft rule states, and I quote, "In case of an auditor, whether an individual or audit firm, the period for which he or it has been holding office as auditor prior to the commencement of the Act shall be taken into account in calculating the period of 5 consecutive years or 10 consecutive years as the case may be." This transition for bigger companies will be a daunting task.
The purpose of that is always to give that perception that, to sort of stop the long association risk of a firm. At the same time, we will be the only, major economy in the world who would have adopted mandatory firm rotation currently. There are other major economies who have tried it in the past and learned that it hasn't really worked. So one would have hoped that instead of going for a, big bang approach and prescribing rotation for, as it currently reads, all listed companies and everybody who is other than a small company or a one-man company, everybody else will have to rotate their auditors, after 10 years, which is, that population is too large. I would have expected that population to be more contained. The Sensex, the Nifty companies learn from that experience, see has it actually worked to achieve the original objective of enhanced auditor independence, and if it does, having learned from the experience, expand the coverage. So overall, absolutely, it is retrospective the way it's written in the rules. Will people challenge that the rules actually go beyond the Act or not? I'm quite sure they will. I've already heard other firms in the marketplace talk about that.
The draft rules explicitly indicate barring network firms from being appointed in rotation as auditors of a company, but rendering of managerial services by the very same audit firms is somewhat a grey area that experts seem to be worried about.
Introduce the principle of rotation. There will always be this issue of how do you ensure that the firm which you appoint is independent. And therefore, for instance, let us say as a firm, as an auditor, I am rotating out of a company A. And I am expecting company B will appoint me as auditor. Now, I don't even know whether company B will appoint me as auditor or company C will appoint me as auditor. So does it therefore mean that I stop rendering services to companies B and C in the hope of being appointed as auditor? So it will raise issues in terms of, it will create operational difficulties. But it's nothing to do with the services being proscribed, as opposed to the fact that in the compliance with independence rules becomes difficult when you transpose rotation onto both national and an international plane, because one will have to be independent for international firms on an international basis across the globe.
However, interestingly, the draft rules has also warranted several disclosures in the auditor's report, like making all litigation with respect to finances and provision of contingent losses in the long-term contracts, including derivative contracts. Experts feel that these disclosures can create confusion while reporting in line with international accounting standards and could make auditors' report unnecessarily bulky.
But the challenge here will be that not all losses on derivative contracts will be accounted. If a derivative contract is part of a hedging strategy, then there is no provision which is made. That portion of the gain or loss is depending on whether it's a cash flow hedge or whether it is a fair value hedge. And generally many of these are cash flow hedges, will be carried to the balance sheet and will be recycled into the profit and loss account when the hedged item also hits the profit and loss account. So there is no provision effectively which is made now in those cases. So that needs to be cleared out. So that sort of guidance, I'm sure, will come out.
While companies and various stakeholders await to see the entire set of draft rules to be put out to gauge the full impact of the Act, industry sources say that the entire set of rules are only expected to be rolled in 3 phases by the end of this month. And it will be some time before we know what the new law brings.